My name is Axel Frazzini, and I will be your host today. I'm the Managing Director of 4IP Council. And just in a few minutes, I will just introduce what 4IP Council is about. But as an introduction, if you don't know us yet, we are dedicated to high quality academic research, education activities, and the promotion of innovative SMEs using IP to grow their businesses. At 4IP Council, we develop robust empirical research and academic insight on policy proposals. The invention process, innovation, impact, and intellectual property themes, we work with a wide variety of academics, experts, IP organizations, and stakeholders on a range of educational initiatives related to innovation and the strategic use of IP. We believe that intellectual property is a bridge that connects invention to entrepreneurship, job creation, and growth. As it has long been our position that strong intellectual property regimes foster the entrepreneurial behavior that underpins innovation, driving social and economic prosperity, 4IP Council seeks to assist Europe and the world in creating a friendly framework that fosters an entrepreneurial spirit and venture finding in complex technologies. On our website, you will find free materials from summaries of papers, studies, guides, case law, interactive graphics, interviews to inspire SMEs, as well as webinars like this one, which will be recorded and posted tomorrow. The goal is to educate our audiences on topics related to IP and innovation. We continually organize, host, or co-host a number of webinars throughout the year. Let's have a look at one example of what we are publishing. Here is a dedicated section with summaries of European Court decisions rendered after the European Court of Justice handed down its ruling in the Huawei versus ZTE case. The summaries focus on the core issues raised by the decisions. This section is now available in Chinese and Japanese. So feel free to visit the website. It has been entirely refreshed lately, as well as the research section. But without further ado, let me introduce our great speakers today, Professor Nicolas Petit and Richard Very. I'm pretty sure that you know already both of them, but let me read a few sentences of their bios. Professor Petit holds the chair in competition law at the European University Institute and the Robert Schuman Center for Advanced Studies. Nicolas Petit is also invited professor at the College of Europe in Bruges and a full professor at the Law School of the University of Liège. He is a co-author of the academic paper Friend Licensing Levels under EU Law with Professor Jean-Sébastien Borghetti and Dr. Igor Nikolic, which was published in February 2020. As a reminder, the paper was quoted by the European Commission's CEP expert group, as well as regional courts in Munich and Mannheim. Last but not least, the paper is nominated by Concurrence for the Antitrust Writing Awards 2021 in the academic articles intellectual property category. Congratulations. And we have Richard Very, who is a partner in Bird & Bird's intellectual property practice and tech and communication sector group. He specializes in multi-jurisdictional electronics patent litigation with a particular focus on mobile telecommunications, patent litigation, and arbitration work. He also has extensive experience of dealing with IP transactions and strategic IP advice. So to have this event start, I would like to remind you that you should be able to find a Q&A tool on your screen where you will be able to ask directly your questions to the speakers. We had also created a form, an online form that you were able to access after the registration process to ask your questions. And we have received a lot of questions. So to facilitate at least the start of the webinar, we have divided the questions into 5 categories, and we have tried to simplify the question that we have received. So this is a start, and I will really urge you to ask your own questions directly through the Q&A tool, not the chat, okay? And we will take the questions along the questions that you can see on your screen. So the questions that we have received are, as I said, split into 5 categories: the background, implications for the automotive industry, the CJEU referral, the debate, and hypothesis. Without further ado, let's get started. So just checking, Nicola, you're muted. Richard, you're not muted. So that should be good. The first question that has been asked many times is related to the background. And could you explain in a nutshell the Nokia and Daimler dispute?
Yes, of course. So this is it's a commercial dispute, and it's at its heart, it's a dispute about how much a patent owner, an SEP owner like Nokia, should be compensated for use of the cellular technology in a new field in the automotive space. Daimler has been using cellular technology in cars since about 2008, and gradually that use has become more extensive. And there was Nokia approached it after some time and invited it to take a license. Daimler's response was to ask Nokia to talk to its suppliers, principally the tier 1 suppliers, and its position was that their role in the licensing chain is to take the licenses for this sort of technology and to pass on to Daimler a fully licensed product. So Daimler referred Nokia to the suppliers. So Nokia formulated a license agreement of the sort that could be entered into by the suppliers. That didn't go anywhere. Negotiations on that didn't progress, and eventually Nokia bought patent litigation against Daimler to try and collect royalties on its patents. There were a number of cases in Germany. There were a number of successes, and after a while it was established that there were valid and infringed and essential patents in the portfolio. In the meantime, the suppliers and Daimler had brought a complaint to the European Commission, and their complaint was based on the structure of the licensing proposals that Nokia had made, and that's very much the topic of this webinar. Eventually, there was a case in the regional court in Düsseldorf, and whereas the Mannheim and Munich courts, which tend to be quicker, had gone ahead and either found infringement and granted injunctions, or perhaps stayed the case for if there was concerns about validity, or in some cases found non-infringement. The Düsseldorf court came along rather slower and referred the question to the CJEU about licensing levels. So that was where we got to. The Commission had also organised a mediation, and as an attempt to try and reach some sort of agreement between everybody. It was a mediation involving Daimler, all of the suppliers, and Nokia. And following that, Nokia took some feedback about its offer that it had made to the tier 1s, and it modified that and it made a further offer. But then eventually, I think 3 weeks ago, 1st of June, there was a settlement announced between Nokia and Daimler, which brought the litigation to an end.
Okay. Thank you very much. So it gives really a full context and the background. Now, let's have a look at what the academic world is saying based on the main findings of the friend licensing levels under EU law. Maybe, Nicola, you could introduce your paper and the main findings?
Okay, sure. I can do that. Can you hear me?
Yes, very well. Okay,
very good. So the question that you ask here is pretty straightforward, and I think the answer is equally straightforward. So if the question is, you know, what did we find in the paper, and is there a source of obligation in EU law bearing on standard essential patent owners to license at one specific level in the industry, or whether there is freedom, I think the answer is that there is there is more freedom than obligation in the law. So let me maybe say a little bit about the main takeaways from the paper, and I think there are essentially three things to keep in mind. One is EU law, be it competition law or EU constitutional law or EU law on discrimination, lets standard essential patent owners free to select the level at which they can license. And this statement is a strong statement, but it's essentially what we have in the law. It's a regime of freedom of selection of the level at which the rights holder wants to license. The second takeaway is that a SEP owner is free under EU law to license at one point of the value chain for the entire value chain. There's no obligation to go at each level in the value chain. So it's equally clear that this freedom to select is also a freedom to, in a way, extract the value at one point in the entire value chain. And the third point, which is more general, and it's actually a point that is made in the paper throughout the paper, but it's one point that anyone who has followed the history of these disputes between SEP owners and implementers related to front licensing, it is that every time the Court of Justice or the European institutions have been asked to solve these revenue sharing disputes, they've always taken very indirect and light touch approaches. So whereas people want the law whereas some stakeholders want the law to step in and provide very clear statements of obligation on SEP owners, or very clear statements about the sharing of value between SEP owners and implementers, I think the output that we've observed in the European jurisdictions and agencies in one in which there's a lot of reluctance to actually affirm very strong principles of obligation on SEP owners and reluctant to specify the levels or the formula, the methodologies, and the targets at which these licensing deals have to be made. So the point is, freedom is a principle that dominates the case law of the EU courts and the decision-making practice of the agencies. I hope that's clear.
It is very clear. Thank you. So you have also covered the question 3. I think we can move ahead to the question 4. And why did it take so long to Nokia and Daimler to sign a patent licensing agreement? Richard, maybe you could shed some light on this one.
Yeah, so there's a few reasons. I mean, first of all, if you worked in a large company, you know how long things can take to move. You have a lot of people that you've got to bring along with you, and a lot of people that need to sign off on things. And when things are, let's say, important but not urgent, there's no imminent threat to the company, then things can move really very, very slowly, because everybody's got something more urgent on their desk. So you have that, but then of course there's a lot of interest to satisfy in this case. It's not just Daimler that needs to be convinced. There were all of the suppliers involved as well. And Daimler wants the suppliers to resolve the situation. The suppliers are having to sort the themselves as well, and reach an agreement. And patent litigation too is a very slow process. Even in the quick courts, you're still taking a year or more to get to any sort of decision. And then with injunctions being stayed and appeals and all that sort of thing, it can take 2-3 years before there's really any urgency on anyone to do anything in patent litigation. It can take a very long time. So you have all of that going on. And also when you're the implementer, you know that even if you are eventually injuncted, if there is an injunction against you, you can always just take the offered license and end the problem there and then. So there's no real rush to do anything in particular. And that's why these things can take an awfully long time. And patent litigation is extremely complex and time consuming, and and slow.
Okay, okay, I better understand. I see in the Q&A a few questions related to the value chain licensing. So maybe we could come back to question 3, Nicola, in case you may want to provide further clarifications.
Yeah, so the question was what value chain licensing requirements does the friend commitment actually impose under ILO? And this is a question that we really carefully considered in the paper. And if you try to read the practical implications of what the law in the books and the cases are, there's essentially, I think, 2 requirements that the friend commitment imposes in terms of value chain licensing. But you're going to see it's pretty minimal. So the first one is that if you start to license at a specific level in the value chain, you have to treat people at the same level of the value chain equally, right? So the people, the market players that you license in at the same level in the value chain have to be treated somewhat equally, and the patent owner has to avoid a situation of discrimination. And well, this is a very standard principle that that is imposed on contractual by contract law and by competition law. So that's one. The second requirement that EU competition law this time creates through the friend commitments is an idea, is an obligation on licensors with integration in the components or in the application, in the implementation, to refrain from using licensing as a leveraging instrument to exclude competing components or implementation suppliers. So if you're a SEP owner and you have vertically integrated into a specific component and you start to license out to competing component manufacturers, EU competition law is very clear that you have to make sure that you're not using your power to license in order to, as a power to exclude competing component manufacturers. So these are the real 2 requirements that apply and restrict the freedom of SEP owners when they enter into value chain licensing transactions with implementers. So non-discrimination 1 under contract law and competition law, and 2, a requirement not to strategically exclude competing value chain implementers if you are yourself vertically integrated, which means that companies which are non-implementing manufacturers under the Huawei judgment remain quite free from antitrust liability. In a way, it's some people think it's too lax for non-practicing entities, but this is the implication of the wording of Article 102 and the reading of the Huawei ZTE judgment, literal and a theological reading of the judgment.
Okay, thank you for the clarification. I see more questions coming. I suggest we move to question 5. Richard, yes?
Okay, yeah, there's a couple there which start, Des and Romola, both suggest that there was only 1 patent. I should be clear, actually, I'm sorry about that. There are thousands of standard essential patents, and of course, when they get litigated one by one. But the license agreements involve many thousands of patents, not just the 1 or 2 that were litigated.
Yeah, of course. Yeah, that's good clarification. I see many questions that are actually related to the question 5 here. So what are the next steps now that Daimler has signed a licensing agreement with Nokia and all litigation between the 2 parties has been resolved, including the referral to the CJEU?
Yes, that's right. So Nokia withdraws all of its infringement actions. Daimler has withdrawn its complaints against to the European Commission against Nokia. But of course, that doesn't necessarily affect the various tier 1 suppliers. And they publicly stated their intention to fight on. There's also an ongoing case between Huawei and Nokia, and Huawei in this case is acting as an automotive supplier because it supplies certain modules that end up in automobiles. That's in the regional court of Düsseldorf, and we'll have to see where that one goes. But I can see that there's scope for another reference to come out of that in the future on that, or perhaps on a different case. And of course, the arguments about the appropriate licensing level in the automotive sector, those continue to be part of the ongoing policy debate and things like this.
Okay, quick follow-up. I see. I think that's for you, Richard. What will the licensing relationship between Nokia and Daimler be when the patent expires?
That's right. So obviously,
and that's not one patent, that many.
Yeah, that's right. There's not a single patent. Obviously, when all of the patents have expired in this technology, then no one needs to take a license anymore. They become the technology becomes public, and certainly for things like 2G, most of the patents in 2G have now expired. So it's, that is falling into the public domain, and that's the effect of having these very limited periods on of patentability. But the same will be true of 3G eventually and 4G eventually.
And then 5G, etc.
Exactly, yes, when we're old men.
I send us a question. I suppose that's for Nicolas Petit. In addition to EU law covered by Professor Petit, is there anything in the relevant SDO, and especially the ETSI IPR policies, about component level licensing? Because I believe it is part of your analysis in the research paper.
Yeah, so we have, thanks, that's a good question. I wish my co-author, Jean-Sébastien Borghetti, would be here to address it, because he's the one who did the heavy lifting on this. But I think the paper provides a careful analysis and thorough analysis of the degree of legal obligation arising from contract law as a result of participation and commitments of patents to SDOs and the subscription of the taking of FRAND pledges. I think that the conclusion that we reach in the paper is there's fairly little actually to find here. Now, one thing that I worked more personally in the paper on is this idea that appears in the Huawei ZTE judgment of legitimate expectations, which is in a way a sort of contract law concept. I mean, in EU law, it's a constitutional law concept, but it derives from ideas of reliance, expectations, and so on. So theories of contract or quasi-contract law. And in Huawei ZTE, the court has this statement in which it says a FRAND commitment creates legitimate expectations on third parties that they will be able to access technology patent essential to a standard in under FRAND terms. And what is there to leverage here as a source of legal obligation, again, is very unclear, but the case law of the Court of Justice on legitimate expectations is very accommodative of conditionality, of leaving ability to parties to operate within legitimate expectations, and it's only in very extreme circumstances that the Court of Justice accepts to consider that a declaration or a pledge, like a FRAND commitment, create expectations which are legitimate and allow reliance. So again, if you just read the case law in a very sober way, it's very hard to find there a source of help to renegotiate or perfect or complete or specify contracts which have been which have been under-specified at the standard setting stage. So that's all I can say, really.
Okay, that's good. I suggest we move to the implications for the automotive industry. Now that we have seen that the dispute between Nokia and Daimler is finished, that referral is also stopped, and the first question that we got many times actually is, considering that Daimler is now a licensee of Nokia, why did Continental, that is a supplier of Daimler, declare they will pursue their complaint with the European Commission?
So the simple answer to that, of course, is that Daimler is not Continental's only customer. Now, it may well be that this settlement encourages the other automotive OEMs to enter into licensing negotiations, either with Nokia or to take an Avanci license. But in the meantime, Continental has got other customers who are not currently licensed to the patents. And although Daimler is a very big company, they're by no means the biggest. Mercedes is by no means the biggest car supplier out there. So from Continental's point of view, it's still very much in their interests to get the most favourable deal they can for their other customers.
Okay. And maybe the follow-up question is, why do suppliers keep asking for a direct license when consent can be obtained indirectly through the have-made right clauses inserted in a license agreement, in their case with Nokia? In both cases, consent to use the patent is understood to have been given, so there would be no infringement by either the OEM or its supplier.
Yeah, so this is a fun debate that I have been. I don't know if Damien Girardin is watching this, but a fun debate that Damien and I have had in a number of papers going backwards and forwards. And it's interesting. So stepping right back, tactically, you've got the suppliers want to be the ones who are able to negotiate because they think that they can negotiate a lower price. If you're negotiating what the price of the license agreement is, and you're the car maker, and there are various people who have written academic papers or carried out studies and established that connectivity is adding many hundreds or even thousands of euros of values to your end product, it's very difficult from that position to turn around and say, if I pay 1 or 2 euros in royalties, that would be excessive, and that would put me out of business. That would not be sustainable. So an excessive pricing argument, a too expensive pricing argument, is really hard to maintain at the vehicle level. It's much easier to run that sort of argument as the implement of the licensee if you have perhaps a margin of only a few euros per product. And in the automotive industry, the supply chain has really tight margins. The level of efficiency that they have achieved in their supply chain is astonishing, but it means that 1 or 2 euros on the price of a component means that the supplier goes from being profitable to being unprofitable. So they have this ability to say, if they're halfway up the chain, we can't afford to pay much. As a negotiating tactic, it's a bit like running out of the restaurant and leaving your least well-off friend who's only got 50 euros in his pocket to pay the bill. You know that by doing so, you've very much capped the amount you're going to have to pay for the evening's dinner. Now, the have-made rights, which the patent owners say, they say you can license it at the end-user product level, and everybody else in the chain gets the benefit of a have-made right, and that should be fine. The arguments that are deployed against those, and read Damien's papers because they're very good on this, the arguments against those are that have-made rights under German law are actually very limited in their scope. So a have-made right could only authorize, he says, one level down the chain. So when you have a multi-layer supply chain, a have-made right, he says, could only deal with one level. He also argues that a have-made right is limited to the supplier producing something to the design of the manufacturer. This is, he argues, under German law. My counter arguments in the papers are that have-made rights are contractual things. They can be as broad or as narrow as you write them. So if there is a problem with how narrowly they're construed, then just write them in a way that they're broader. And also, the last argument that's been made against have-made rights is that they don't allow research and development. And from the patent owner's point of view, the argument is you don't need a license for research. It's not an infringing act under a patent. But equally, if that's the problem, just write it in, and then it's solved. So there's the arguments that have been deployed either way on that.
Okay, now this is very good. Now jumping to question 3, and then I see that we'll take one of the questions received in the Q&A. Question 3 says, according to the press in November 2019, Nokia made an offer of an end user license to a supplier, Continental. We know that there was no agreement signed with Continental. Could you please share what happened? Did Continental refuse to license? Did they reject the offer? If so, how did they justify such behavior?
Okay, so yes, we know from the press release that there was a license agreement offered. Again, to some extent, that license agreement, the terms of it are described in the exchange of papers, so I can talk about it publicly. It was a thing called the CVVCL, and this was Nokia's first attempt to satisfy this request by the automotives and the tier ones, that the tier ones negotiate and enter the license agreement. And it was a structure where a tier 1 supplier could enter the agreement, and as a result of it entering, then any vehicle that its component went into would be licensed, and then have-made rights would protect all the way up the chain. That wasn't accepted by Continental. I'm not sure that I could say that they expressly refused to license or anything like that. That would be putting it too far, but certainly they didn't accept that agreement. Then there was a second license agreement that was offered, which you can read about in the Düsseldorf judgment. And that was supposed to correct some of the problems that were identified in this the first attempt, or the arguments that were made against the first attempt. And that was very clearly a direct license to the suppliers. But that wasn't accepted either, or at least it hasn't been accepted yet, is probably the best way of saying it, that Daimler has settled in the meantime.
Okay, that's good. I see a question. Has there been any consideration that patents in the portfolio may cover different levels in the ecosystem, i.e. component, device, infrastructure, combinations of those, etc.? And if so, how has that impacted the determination as to where in the chain of distribution the license should be taken? Yes,
so that's quite a good question by someone who may have read a couple of papers in this area. There are patents, standard essential patents cover all sorts of things, but what they're really trying to do, or what the standards are trying to do, is they're trying to standardize the interface between two connected units. So patents don't describe how to make a mobile phone, they don't describe how to make a base station. What they describe is how the two must interact between each other. So for the most part, the patents are primarily directed at a mobile phone or a connected car operating in a radio network where there's a base station as well. So as a result, they tend to be written at that level. Quite often there will be a method claim, which is describing the interaction. Quite often there will be an equipment claim, which describes one of those two terminals, the base station, the mobile unit, the car, the phone, or even both of them. So many patents are at that level. There are some standard essential patents that read at component levels higher up the chain. Now, I know from my own experience when I was digging around trying to find standard essential patents to assert against Qualcomm, that there are very few standard essential patents in the world that can be read at the level of the chip, the baseband processor, the transceiver, those sorts of things, because the majority of them require things that are going on much higher up in the network, and that's fine. Now, what does that mean? You could, in theory, I suppose, have a licensing structure where the patents that read onto a component are licensed to the component, the patents that read higher up the chain on some intermediate product are licensed at the intermediate product level, the patents that read on the end user device are licensed there, and then the patents that are only infringed when the end user device is operating in the network, maybe the end user has to take a license to those. But it's a horribly complicated system. You would have huge arguments with everybody saying, no, I don't infringe that one, that's actually infringed at a lower level. End users, clearly, we can't be licensing to. So much better system is to have a single point of licensing somewhere in the chain, which was the model that evolved in the mobile industry. And then the argument, of course, is at what level do you license? If you license at the end user product level, you capture everybody, that's fine. If you license at some intermediate level, you would then have to have either the intermediate product maker taking a license to patents that he doesn't infringe for the benefit of the people down the chain and sort of passing the cost on to them somehow. Or you would have to create some sort of contractual mechanism by which the licenses are then passed further up the chain as well. There would have to be some mechanism to deal with the fact that exhaustion isn't going to cover you in that situation.
Okay, this is clear. Last question in this section, which is Daimler is a licensee of Nokia, but not a licensee of the Avanci marketplace that counts 41 licensors, including Nokia. Does it mean that Daimler is far from being out of the wood? Or maybe they have other already direct licensing agreement?
Yes, so there's obviously two ways of going about licensing is when you're the implementer. You can either go for the pool licenses or you can go for bilateral licenses with everyone in the chain. Daimler has already taken a couple of bilateral licenses, so maybe it's set itself on the bilateral licensing route, in which case it will no doubt have to carry on with that. Others may choose the Avanci route just because in one shot it acquires a license to most of the standard essential patents out there. Not all of them, because of course Huawei and Samsung aren't members of Avanci, and those are two quite big patent owners. But it still deals with most of the problem. If you are an implementer, it can make an awful lot of sense to take licenses as slowly as you can and perhaps negotiate them bilaterally. And the reason is the effective limitation periods. If you've been using the technology for more than 6-7 years, which many of the automotives have, then every year that you don't take a license is effectively a year of free use of the patents you've had in the past. And so the longer you can delay and the longer you can stretch it out, the less overall, the less period of time overall you end up paying for. So there are very sensible reasons to delay, and it might be that if you're an implementer in a car company, you've chosen a strategy of, I'm not going to take a license from Avanci, I'm going to sit back and wait and see who actually sues me, and then as it becomes necessary, see what licenses I can negotiate with those, because all the time the clock is ticking, all of that time, all of my past liability is getting washed away by the effect of these limitation periods. So it's a perfectly valid and sensible strategy to delay and see how long you can avoid taking licenses.
Okay. Let's move on, please. Quick reminder: use the Q&A tool. I see that we have many questions that have been asked, but each time they are covered by the following questions. So don't worry. I'm taking the questions where I know that won't be covered. The referral. So do you consider the referral by the Düsseldorf court to the CJEU to be justified? i.e., do you consider that clarity is needed in establishing the owner's obligations related to the production chain, or are you of the opinion that the referral is only justified because the Düsseldorf court has a friendlier position in relation to the implementers? And secondly, do you think that this referral will lead to refusal on the part of the owners to go to this court and be forced to go to another court to litigate the dispute, for example, Munich or Mannheim?
Yes, okay. So first of all, this wasn't really the right case for the referral, I don't think, because the referral and much of the summary and much of the discussion about all of this is premised on the idea that Nokia was only offering licenses at the end user product level or was refusing to license the component makers. And unfortunately, the facts didn't quite fit that. It's never great to have a referral on a case where the facts don't quite fit the questions that you want to refer on. So I don't think this really was the right case for that referral. I think the referral was very slightly based on a bit of a false premise there. Now, I think I would agree, and I noticed that the SEP Working Experts Group also agreed that a single point of licensing is a sensible thing to do. And if we're going to have a single point of licensing, we have to have some understanding within the industry of where that point is going to be. And a convention evolved in the mobile phone industry, and that was straightforward, and it meant that this problem didn't arise. For the car industry, I think it's going to settle down at some point. It might be the tier ones, it might be the OEMs who agree that they will be the ones that take the licenses. And as between those two, I suspect there's an awful lot of SEP owners who are sitting back and saying, I don't really care so long as someone does. But we've just got to reach some sort of agreement and accommodation where everybody isn't just pointing to each other and saying, no, somebody else should take the licenses. Whoever it is, it's not me, which is the current confusion. Now, whether the CJEU can solve that, I don't know. I would hate to be a judge in the CJEU had this question come up to me, because what you're asking them to do is to form a definitive opinion in an industry that they don't know, or a definitive opinion that's going to go forward to lots of industries that we don't know and we can't even foresee at the moment, covering trillions of dollars of device sales over the foreseeable future. And the poor chaps only get 15 minutes of submission from one side and 15 minutes from the other to encapsulate all of this incredible complexity and make a decision. And if I was a CJEU judge faced with that, I think I would have ducked the question in some way or other, or confined it really specifically to some very, very particular facts. So I think perhaps this question is not susceptible to answer by that sort of court, and it's probably not susceptible to answer by any sort of court. I think it's a question that has to be answered by some sort of industry initiative, and for each different industry, the answer may be different because the issues at play are going to be different. So that I think is probably the answer on that. There was a second part to the question, wasn't it, which is, would people avoid Dusseldorf? And I think the answer is they already are, unfortunately. So Dusseldorf is an excellent court. It is technically probably one of the most rigorous patent courts in Europe. But I think at the moment, if there is a danger that your question is going to be referred off to the CJEU and there will be a several-year delay, it's fantastic for lawyers. It's not great for for industry. So I think people already are. But of course, if you are avoiding the Dusseldorf court, then I think the place probably to go is not Mannheim or Munich. I would advocate the UK for obvious biased reasons.
Okay, and some people asked in the online forum, in case you have a crystal ball, there is an ongoing case in Düsseldorf between Huawei and Nokia, and you told us about it earlier. Should we expect a new referral?
I think it's possible. Yes, I'm not sure how the Düsseldorf court is going to address it. I think if there is another referral, it will probably only deal with the sort of the A. Do you remember in the referral there are two groups of questions? There's A, which is to do with levels of licensing, and then there were a set of questions that were on the B, which were more to do with the implementer's behaviour and were really addressing the CISFEL higher Federal Court of Justice decision. Not really relevant to the Nokia and Daimler question. I suspect if there is another referral, it will probably confine itself to the A-type questions, not the B-type questions.
Okay, good. Now moving on, the debate. And the question is, the research paper of Nicola Petit, Dr. Nicolas and Professor Borghetti looked at the general principles, patent, contract, and competition laws, and concluded that the EU law does not require a license to all approach. So is the debate between license to all and access for all the wrong debate after all?
I guess that's a question for me, right?
Yes.
Okay. So I was thinking a little bit about what Richard was saying, and I liked the picture that he gave of SEP owners facing a population of implementers, and these implementers, they are part of the same supply chain, and they're pointing at each other to say, I know, I'm not paying, he's paying, she's paying, he's paying, she's paying, that sort of stuff. And I was trying to, so I was trying to think through that, and I think that links to the question in a more economic way. And so if you're the social planner in a society, what you want to achieve is you would like to minimize transaction costs when transaction costs are high in order to allow efficient bargaining. And here, I think the case law that we have solves the main transaction cost that we have, which is you have step owners who are not necessarily vertically integrated, who have to deal with supply chain that they don't necessarily know very well. It's another business. And so when the case law says the step owner can select the level at which he or she will license, that solves the transaction cost uncertainty of figuring out where to license. In a way, it says, you can license where you want rather than license everywhere, or you don't know, we'll see later. So that's good. So the law, by doing that, actually reduces transaction costs by clarifying that there's freedom to select. And then that the law doesn't really deal with the rest is not a problem, because within a supply chain, you can certainly assume that the transaction costs are lower compared to the SEP owners to value chain transactions. Within the same value chain, you can assume that the transactions there are lower, because the people who sell components to manufacturers and manufacturers who buy components to producers are in this business for some time. They know each other. They have generally contractual relationships that are established, and so there's channels of trade which are already established. So I think the question in a way is that the status of the law today is sufficient to eliminate the first big transaction cost problem, and is good, because the second transaction cost problem that we have is just bargaining between various players in the value chain who know each other pretty well. So in a way, I think that by essentially saying the law doesn't really say, the law leaves freedom to select the level in the value chain. And by doing that, the law has reached what I believe to be a pretty decent equilibrium in a free market economy.
Okay. Okay.
That's good. Makes sense.
And yeah, no, it makes sense. And maybe the following question is a bit related. You have some people who better know IP in the telecommunication, IP transactions. Some are very familiar with the standard essential patents, and some are less familiar. So maybe is it correct or not to believe that the core of the issue is actually the lack of IPR knowledge of the non-telecommunication stakeholders, for example, from the automotive industry, who are now implementing technologies that are outside of their know-how? Or maybe that's totally not correct. And can you shed some light on this?
So on the auto side, obviously the automotive industries have extremely good IPR managers. They have many of their own patents. Daimler is one of the biggest patent holders. So they are relatively sophisticated. But one of the things I've noticed throughout this debate is the number of my old colleagues, and either people I've been on the same side as or have been opposed to, are now all involved in one side or the other in this debate. And it's a lovely thing about working in the industry. It's the same faces, the same old friends, new arguments on different sides. So many of the former telecoms guys are now in the auto industry and are running these arguments. They've got now the experience and the expertise that they need, just as the new telecoms manufacturers, when they enter the industry, they tend to pick up people as well. There are former Qualcomm, former Nokia guys, former Ericsson guys all over the place now. So they're learning. I have much more sympathy with the small IoT startup. When that problem comes along, then we are going to have to work on educating, and we're going to have to find ways of giving very cheap, very good advice to those who are entering into the market. But I don't think that's the issue with the big auto players. I think they're very well manned up now.
So what you're saying is the big companies have the skills, they know what they're doing. And then I can see a question in the Q&A where it says, how does the delaying tactic on taking a license square with willful infringement? If they know what they're doing and they're not taking a license.
So there's been a couple actually, and Patrick McCutcheon also made a very similar point about, is it not worse for you if you delay taking the license? And the answer is, under European patent law and English and German, the answer is no. And the damages are what you would have had to pay anyway. We don't have any concept of willful infringement. We don't have multiple damages or any of those sorts of things. So no, that's why it may be somewhat different in the United States, but obviously we're talking about Europe. There was, while we're at it, actually, Seiko Hidaka also asked a very good and smart question, which tells you how much that she knows about patent law. And this is about the ability to use indirect infringement. And the answer to Seiko's question is, of course, the end user, you or me driving the vehicle, we get covered because the vehicle maker takes a license even for the patents that we directly infringe. They get through their indirect infringement. But indirect infringement's got that massive limitation in it, which it is territorial. You have to say there has to be infringement in the country, knowing that it's infringement in that country where the product is sold. So it doesn't work cross borders. That's why the indirect infringement model can't be used for the component maker who may make a chip in Taiwan, export it through Singapore, it gets put into a TCU in the United States, gets put into a car in Germany, which then gets sold in England. Indirect infringement just won't follow through those border crossings.
Okay, very good. Now we still have a few minutes. I would like to move to the next section, which is hypothesis. And I like this one. Hypothesis 1, imagine the Düsseldorf court refers the Huawei Nokia case to the CJEU. Hypothesis 2, suppose the CJEU would rule in favor of an obligation of the CEP holder to license Tier 1 and Tier 2 component manufacturers. The question is, will that not contradict its own case law under 102 with respect to anti-competitive refusals to supply?
Okay, I get it.
Yes. Go ahead, Nicolas.
Okay. So again, I mean, I'm always very uncomfortable with these questions because they tend to infer that competition law is a prescriptive law or body of principles which say what people can do, cannot do in various sets of detailed circumstances. It's not what competition law is about. Competition law is a prescriptive, prohibitive form of law which only applies in marginal circumstances. So it doesn't say you can do this, you can do that. It's not command and control, socio-economic engineering of market transactions. It's not economic regulation. And so saying, oh, would it contradict the case law in 102 if the court was to say there is an obligation on the CEP holder to license this? You know, the court would probably not say there is an obligation to license here. The court would say the refusal by a firm to license that manufacturer in these circumstances constitutes an anti-competitive abuse because of the bad consequences it has on market competition. It's very different from saying you must license here, even if that might be the implication in the particular case, in the marginal case. So that's for a start. Then I think the court has not said or has not affirmed the principle whereby CEP owners can license wherever they want. The court has just said that Article 102 does not prevent a licensor to select the level at which he or she wants to license, which is a nuance, which might be difficult to perceive, but it's an important nuance. Now, I want to say just maybe one thing that allows us to read a possible answer into the question, and it is the following. So rather than the court, the European Commission has dealt with cases involving step owners' potential refusals to license and step owners' licensing conduct towards certain types of certain levels, like manufacturer level or end user device level. Like, the case between the Motorola decision of the Commission, or the case involving Samsung and Apple. And in these cases, the Commission could have picked a principle, because the Commission is free from, it's free to run antitrust cases under the theories of liability that it believes are the one that represent what the law is. The Commission could have said that it was wrong for a company like Samsung to seek licenses at the end users level. The Commission was not bound by the arguments in the complaint. The Commission can bring its own arguments on board. And every time the Commission was asked in these SEP cases about this, issues such as is an injunction seeking an abuse of dominant position, it could have brought other issues on board and decided them. But in these cases, in none of these cases, the Commission actually said that it was the wrong target that had been subject to a license. So the decisional practice that we have from the administrative agencies, which have spent 20 years free to invent theories of liability of this kind, they've never done that before. So why would this now be a problem? So maybe it's just an indirect response, but I think it's funny that okay, I'll close here. In this discussion, and I've been in this game for quite a long time, and I don't work on this daily, but I sort of make intermittent incursions into the discussion every 1 year. I look at what happens, and what I see that it's always the same discussion, but every time people who've lost the previous battle try to change the goalposts or change the framework of reference. It's like a game in which you play on different maps every time, right? It's a video game, so you change the map. So 10 years ago it was about injunctions, and then it moved to SSPPU, the methodology to calculate the value. So lost on injunctions, okay, let's talk methodology. Lost on methodology, okay, let's talk about licensing level. And every time the agencies and courts, they say, but we don't really want to put our hands on that complex discussion because it's revenue sharing essentially, and at the margins, it's a content problem. And so I just wonder what in 10 years the new map of this revenue sharing game will be. People like Richard can probably speculate more clearly about that.
Indeed. Before speculating, let's try to close down with the last question on this slide. And thank you very much, Nicola, for your insight. So the confidentiality of the licensing agreement between Daimler and Nokia has been criticized by one of Daimler's suppliers, which is Continental. Hypothesis: Daimler and Nokia accept to make public the terms of the licensing agreement. Do you think that making this agreement public will help to calm down the OEM suppliers and provide more certainty? Or they really know everything?
Yeah, so this is a debate we have a lot. There's a perfectly valid business model in which you, as the SEP owner, offers published terms and conditions, public per unit rates, and people either sign up to it or they don't sign up to it. And that would work. Avanti offers it, Sysfeld does it, and it's been used in many areas. But it only works if everybody takes those publicly offered rates. But of course, when I'm the implementer, I don't want to do that. What I would do is I would go along and I would negotiate for some special deal based on my unique circumstances. It might be that I'm a high volume implementer, so I want a special deal with a volume discount. Or the other thing to do is drive down the cost by agreeing to pay in advance. So instead of paying however many euros on each car I produce, I go to the SEP owner and say, I think that over the next 5 years, I'm going to manufacture this many cars. If I take on the risk of that, I will pay you a lump sum, and that lump sum will be less than what it would have been if I'd just done it on a per unit rate. And typically, most, I think, of the big SEP cross-licensing and licensing agreements end up being on some sort of lump sum basis, with the value being reduced as a result of the implementer taking on some of that risk. But the problem then is that it has to be kept secret, because that inherently you could work out what Daimler's prediction was going to be of its sales of cars over the next 5 years, and that's, you know, stock price moving information. It's quite important. So that sort of stuff, then it does have to be locked down and be kept secret. It would be quite interesting to have a world where everything had to be open. You have a published price. You can only sell at that published price, and it's illegal for somebody to try and negotiate you down from that. And they either take it at that published price or not. But I think if we were in that world, the people who would object would be the big buyers, because it's the big buyers who use their buying power to get a better deal than the list price. I think that would be the pushback. As for the Continental's objection, I must say the tier one suppliers have all seen the Nokia offers, and their lawyers have been crawling over them for a good couple of years and trying to pick any holes in them whatsoever. So any suggestion that the terms have been withheld from them is perhaps not entirely true.
Okay, that's a very good analysis, I believe. I think we are running out of time, but maybe I could ask you, would you like to, do you see a question that you would have loved to receive and an answer that you didn't and may want to ask to yourself? If not, we can move on. I can see
that last one. Do you think the Huawei decision should become the standard for FRAND licensing? I assume that means Huawei ZTE. I think the Huawei ZTE decision was a very good move forward, and it really did clarify and clear up an awful lot of questions that everybody had in the industry. And more good decisions like that are coming out. I think we are much closer to understanding how this whole FRAND thing is supposed to work than we were when I started in this industry. So yes, I think that is a good point to end on.
Okay. Now that's good. I have the feeling that we could have continued for hours, but now it's time to conclude. And you provided a lot of clarifications, and I hope that it would have helped everybody, at least attending this webinar, to better understand the theory, the real life, what's going on, and to make the connections between the different dots, and just to increase their knowledge, because you increased my knowledge of this highly complicated topic. So I would like to thank you very much, Nicola and Richard, for sharing your knowledge and your expertise. For IP Council really appreciates it. So thank you also to all of you who have attended this webinar. Later today, you will receive a quick email inviting you to complete a 1-minute survey. In case you want to provide any feedback, that would be really appreciated. And finally, as explained before, a recording of this presentation, this webinar, will be posted tomorrow on the For IP Council website. So thank you very much for attending, and enjoy the summer break.
Bye, thank you.
Thank you.